Good morning, everyone. Thank you very much, Carlene, and for the Center and for the Domestic Violence Resource to put together this webinar. Thank you. It would not have been done without your hard work. All of the team at NCJFCJ. We're going to try to lecture for about 50 minutes, 45, 50 minutes, go through my slides. I probably will not be able to go through all of the slides because of the limited time, but I will leave 10 minutes at the end to answer any questions. So we're going to start with a discussion of the concept international family law. Marriage and divorce are no longer local affairs. Many of us have interreligious, international marriages. Life is mobile. I grew up, I was born in New Jersey and lived from 2nd grade to 11th grade in the West Bank in Palestine. I happened to be born in a Muslim family, but I went to a Quaker school, the Friends Boys School in Palestine from 2nd grade to 11th grade. Then when I returned back to New Jersey, I went to a Catholic university and I married a Catholic classmate. And then I moved to England and lived there for 2 years. We travel and we marry, so it's no longer local like it used to be. So an example, and this is things that I've seen in my own private practice. An Egyptian man might meet an English woman in France while they're on vacation, and they decide to marry in Casablanca, Morocco, or Marrakesh, and only to settle later into New York City, with multiple residences, children, assets that are spread in multiple jurisdictions. If the relationship goes south, of course, there'll be multiple laws of different countries that are going to interplay in this international family divorce setting. So today we'll do a brief introduction about the family laws of several Middle Eastern countries. And then we'll do a survey of a lot of cases around the United States involving issues of foreign family law, specifically to the Middle East. We'll address Muslim marriage contracts, validity of foreign marriages, recognition of foreign marriages and divorces and custody decrees, conflicts of laws issues, international jurisdiction in divorce and custody matters, religious marriages, religious divorces, religious rearing issues, and related topics. Like in the United States and in Europe, in the end, nothing comes from a vacuum. Our legal system has a lineage, and our lineage starts with the Canon Law of Europe, evolving into common law and so forth and so on. Specifically when it comes to family law, religious law has always been the overriding primary source of the law in all jurisdictions. Middle Eastern countries, similarly, their lineage is to Islamic family law, Jewish family law, and Canon family law. And these concepts will become clearer as we move forward. Because there's no civil marriage in Middle Eastern countries, with the exception of few, like Turkey, Cyprus, Greece. There are countries in the Mediterranean area where there are civil marriages, but in the Muslim majority countries, there are no civil marriages. All marriages have to be religious, and they're religious governed by the religion of the couple, whether you're Muslim, Christian, or Jewish. When I say Middle East, what do we mean by the Middle East? It's a concept that people have not settled on what it really includes. To many, Turkey, Cyprus, Syria, Lebanon, Iraq, Iran, the list that's on the slide, have been included in the concept of the Middle East. Some even include Afghanistan and Pakistan in the definition of the Middle East. I'm going to use the more broad definition and include Pakistan and Afghanistan and Muslim majority countries in that concept for purposes of our discussion. So in these countries that we've discussed, in Muslim majority countries, the law is religious-based. The law that's going to govern these disputes is going to be based on the couple's religion, whether they're Muslim, Christian, or Jewish. And there are religious courts that have exclusive jurisdiction to determine issues arising out of marriage, whether it's marriage, divorce, custody, maintenance, dowers, inheritance, adoption, all kind of guardianship, all kinds of concepts that items that come under the rubric of family law. And these courts also follow a source of law to apply, and that law is usually a religious family law code. And we're going to go through many of them. So we're going to start out with Christian law in Middle Eastern family law. We'll use Egypt and Jordan as an example. Egyptian and Jordanian law recognize many religious communities. If you're not a recognized community, then you have to apply to the government and you need to get approval in order for you to have autonomy over your family law disputes in your particular community. It's not easy to get approved as a new religious community. So the communities that are approved, for example, in Egypt and Jordan, including but not limited to, are these major ones: the Roman Orthodox, the Roman Catholic, the Armenian Catholic, the Latin Catholic, the Anglican, and the Coptic Orthodox Church. These are recognized religious communities in Jordan and in Egypt. The sources for Orthodox Christian custody law, for example, the New Testament, ecclesiastical decisions, custom, the Jordanian Constitution. The other canon law, family law, that includes certain codes, these communities, the Greek Malachites, the Maronites, Armenian Catholic, Syriac Catholic, Latins, and Chaldean Catholics. These are Eastern Christian communities that are technically Eastern and Orthodox in some respects, but sometime between the 1500s and the 1800s, they entered into a communion with the Catholic Church in Rome, and they are under the authority of the Pope in Rome. The Catholic court has subject matter jurisdiction to hear these cases that involve these 6 Catholic churches in Syria, for example. There's a first instance court in every diocese. There's a court of appeals in Damascus. And in some circumstances, the Vatican court can hear appeals as well. The Eastern Church's Code of Canon defines marriage, and this is very relevant because it's almost impossible if you're a Christian couple living in Egypt, in Syria, in Lebanon, in Iraq, in Palestine, to obtain a divorce because of the religious nature of the marriage being a sacrament for Christians. So this is the definition that's out from the code that is governing Syria, for example. By the marriage covenant founded by the Creator and ordered by His law, a man and woman, by irrevocable personal consent, establish between themselves a partnership of the whole of life. This covenant is by its very nature ordered to the good of the spouses and to the procreation and education of the children. So this is not unusual for a strict Catholic in the United States that is very religious and obtains a religious marriage. Its only surprise here is that this is the law of the land. This is not just a personal religious nature. You are married. What has been united by the Lord cannot be divided or separated by man, is taken very seriously in Middle Eastern countries. So dissolving a Christian marriage is not easy, and it's described as indissoluble. Other than annulment, you have legal separation in the event of adultery, mental or physical danger. So you can have what's called permanent separation. The marriage bond has not been severed, and you remain married, but you're not living together. According to Catholic doctrine, a marriage can't be dissolved. A marriage is a sacrament and it's permanent. The church permits annulment of marriage, but the only way for them to do that is that the marriage was null and void from inception. So as a Catholic in that region, it is very difficult to get a divorce. In fact, there is a recent case out of the Supreme Court of Egypt where a Coptic Orthodox Christian Egyptian was unable to secure a divorce or an annulment from his church. And he filed a complaint against the church saying that he has a constitutional right to dissolve his marriage. And the Egyptian Supreme Court did agree, but that has created a major controversy between the state and the Christian Orthodox Church in Egypt. So I do not anticipate that that law would apply going forward. It is kind of a covenant between all these religious communities and the nation, the government, the secular state, is that we have autonomy over our religious congregates and our religious community when it comes to personal status issues, family law issues. So this is a very, very sensitive circumstance for the church in Middle Eastern countries. So the word talaq, which is the equivalent of divorce in the U.S., even though the word talaq cannot literally be translated to divorce, it is more repudiation than divorce. But that's for a different conversation. But that word itself is not used in the Christian terminology in the Middle East. More interesting is that you have conflict of law issues involving marriage. So you can't even marry within different denominations that are Christian. So it creates, if I am a Catholic a Syrian citizen and I want to marry a Orthodox Syrian citizen, there's going to be difficulty for me to do that. There has to either be a conversion, there has to be approvals from the church, because interdenominational marriages are considered an impediment to marriage. So you can have a voidable or void marriage if you do that. This is an explanation of the conditions, for example, that are from the Byzantine law that applies in Jordan, for example, where if you would need to get approval from your church that they're allowing you and that you would agree to raise the children in the particular church of the husband, for example, or the wife. Here are some of the interesting rights and privileges that arise from the marriage contract according to Orthodox marriage. Husband provides a marital residence for the wife. She has to live there. You need to cooperate with each other, and that Eve was specifically created for the males, and it's a union like the union of the church with Jesus Christ. Marital fidelity. Husband is to support the wife. Unlike U.S. law, support is gender-specific in Middle Eastern system, meaning it is only the male, it is only the husband who has an obligation to support the wife and the children. The wife has no obligation to support the husband. And these are a right to inheritance. This list is in the codification of the personal status law that governs Orthodox Christians in Jordan. There is no concept of marital assets or community property. Finances are separate. And this is provided specifically in Article 138 of the Byzantine law. Each party is free to dispose of and utilize their own assets and money as they wish unless otherwise agreed by the parties. Byzantine law provides reasons for divorce. And again, you have a variety of subtle differences between obtaining a divorce if you're Catholic and obtaining a divorce if you're Orthodox and obtaining a divorce if you're Protestant. So each community has different rules. It is more difficult for a Catholic. It's easier for an Orthodox, but under limited circumstances. For example, if wife was not a virgin on the wedding night, that's a grounds for the Orthodox. If wife intentionally avoids or terminates her pregnancy, wife goes out with a male to eat or bathe, wife sleeps out of the home against her husband's will, unless the husband threw her out for no just cause. If the wife goes to parties, including races, acting, hunting, without the permission of her husband. When you read these lists, you understand the patriarchal system that is systemic in that region, where the entire family law revolves around the patriarchal concept. If the wife committed adultery and the husband proves adultery, or if the religious court ruled that the wife needs to obey her husband and follow him to the marital residence, and she refuses. These concepts are also available under some of the interpretations of Islamic family law. So you see a lot of similarities between these religious legal systems and procedures with all these religions in that region. Wife has limited grounds for divorce, including impotence, if the husband wants her to commit adultery, if she can prove that the husband committed adultery, or abandonment for 3 consecutive a mistress. There are mutual grounds for divorce. Both parties have this right if one of the parties is mad, joined a seminary, conspiracy against the state, conspiracy to murder, criminal conviction of either party, and differences of religion, meaning that during the marriage there's conversion or change of religion. Under the Jordanian custody law, governed by Canon Law, fault is a consideration. The children will remain in the company of the innocent spouse. Judaism in the Middle East, family law. There are very strong Jewish communities prior to the establishment of the State of Israel, Jewish communities that are not European Jews. They're Oriental or Arab Jews that lived very strong in Syria, in Egypt, in Lebanon, in Iraq, and in Morocco. So in many of these Muslim majority countries, the Jewish community thrived and lived for 1,000 years, 1,500 years since the advent of Islam. And they had autonomy over their family law and inheritance disputes. So in many of these countries, there's actually a codified Jewish family law code written in Arabic. It's not even in Hebrew. It's in Arabic. I have native fluency in Arabic, and I have worked on several cases that involved Jewish law in Morocco and Jewish law that was involved in Egypt, for example. So those codes I own in my own personal library. So what I'm going to discuss here is about the Jewish Egyptian family code, which is very, very, very interesting. Article 23 of the Egyptian Jewish Family Code provides that the age of marriage for a boy is 13 years old and for a girl is 12 and a half. As it pertains to income, Article 76 provides that the income earned by a wife belongs to the husband, as long as husband is taking care of his financial obligations to the wife. Now, this is not an unusual provision. It is unusual for purposes of Islamic family law because Islamic family law from inception specifically wanted to separate the income of the wife from the husband, that it would be her separate property. He has no claim to it. In addition, under Islamic law, when you marry, you do not take the name of your wife because your identity does not fuse. Interestingly, just last year, Governor Christie in New Jersey had repealed a series of laws in New Jersey that were anachronistic and really never applied. One of them was a 1913 law that said that a wife should be entitled to her earned income, and it is separate, and the husband doesn't have a claim to it in New Jersey. So it just tells you the remnants or the lineage of our legal system was canon law to begin with. But we are reforming and moving ahead. Divorce under Jewish law is exclusively the right of the husband. Article 324 of the Jewish Family Code in Egypt says just that. Article 337 says that no civil divorce would work for purposes of dissolving a Jewish marriage. Roman Orthodox marriage for a girl is 15 years old, and that's in the code. Syriac Orthodox marriage age is 12 years of age. Now, these are existing laws on the books, but there has been changes over the past 10, 15 years in Egypt, in Syria, and so forth. So there has been civil laws that have been adopted saying that you need to reach the age of majority, which is 18 before you can get married. Some states, countries have reduced it to 16. Some have required parental consent. But you have young marriages taking place in rural areas in that Middle East from all denominations. And specifically when you control the statistics to economic status and educational status, the higher economic echelons with education, the less likely that you're going to have marriages under the age of 18. But in the other rural areas, it's not unusual. So currently, I'm going to be testifying, if all goes well, by the end of this month or early next month in the legislature in New Jersey, because in New Jersey, with parental consent, you can marry at the age of 16. With a court order, you could marry at 15. We are proposing, an organization that I support and I work with, it's called Unchained, is proposing legislation to say that you will not be able to obtain a marriage license until the age of 18 in New Jersey. And we're trying to pass this legislation to stop a lot of these young marriages that are taking place even in the United States. Now we come into the Islamic law area and the word Sharia that we hear quite often with negative connotations, and that is very unfortunate because it's the same thing. If you look at canon law or Jewish law or Sharia, there are substantive provisions or contents of these laws that are anachronistic, are unacceptable to our notions of equity and justice. But that does not mean the entire body of canon law, Jewish law, and Islamic law should be thrown out and set aside in its entirety. It's a legal system that has survived for millennia, evolved, changes, and we should give people the respect that they deserve if this is a system that they like to be governed, to the extent it does not violate our public policy, of course. Sharia is more than law in the prescriptive sense. It's a methodology. It's a process to determine and construct divine meaning. It's a system, a legal system based on the Quran and the Sunnah being the sayings of the Prophet Muhammad and his conduct and his actions. So it's a moral and legal anchor for a Muslim's total existence, whether the way Muslims marry, they dissolve their marriages, the way they eat, the way they treat animals, the environment, how they conduct business, how they dissolve their estate at death. All of that is governed by Sharia. Whether it's a commercial transaction or divorce settlement, or your relationship with your parents, how you deal with your children, it's all governed by honesty, good faith, fairness, social responsibility, and equity. All of this comes under the rubric of what Sharia is. Sharia is essentially an ethical life seeking to please God. And again, you need to understand this particular context based on the moral framework that is present in the Quran. We have a moral framework in the Old Testament and in the New Testament and in the Quran, but you do have provisions in all religious texts that are problematic. But there is an overriding theme of moral accountability and fairness in these religious texts. Is Sharia the law of the land in Muslim countries? Actually, it is not, but it is in some respects in the area of family law. So with the emergence of the nation state post-colonialism in the 1800s and 1900s, the pre-modern methodology of Sharia, which had an uninterrupted period of sophistication and growth and applicability from the 7th century through the 16th, 17th century, that came to an abrupt end with colonialism. Because what happened was, once these states were colonialized, once the Islamic Empire, the Ottoman Empire, was decimated, and the nationalist movements around the world took hold, and you now have nation states, you no longer have this humanitarian, flexible, type of legal system existing. Now you have basically civil codes from France. You have Western commercial codes, Western penal codes. All of these have been adopted by these nation states. The only area of Sharia that continued to have some prominence is in family law. Yes, it is considered a source of the law in Middle Eastern countries, but it really applies mostly in the area of family law and in the area where the commercial code or the civil code has not addressed an issue. And in that circumstance, Sharia plays a role. For example, you'll still find some Sharia commercial and civil concepts that are still present in the civil code. For example, you have a concept that if you have a neighbor that owns a home next to you, you always have a prior right to purchase against third parties. This is a very strong commercial concept in Islamic law. So that has been incorporated in the civil code. But by and large, the majority of the civil code is Western-based. The two primary sources of Islamic law, as we had mentioned earlier, the Quran is the Muslims' holy scripture, similar to the Old Testament and to the New Testament. According to Muslims, it's the Word of God. The Sunnah is essentially the prophetic example. It's the example of the Prophet, his sayings, his conduct, what he did, what he didn't do, what he supported. There are other secondary sources, reasoning by analogy, consensus of the jurists, juristic preference, public interest as a source of law, necessity, custom. Very similar to any legal system around the world. A lot of those general principles apply. There's an analytical process to engage these sources of law to determine a legal issue. And again, this analytical process applies mainly with religious scholars. The legal system in the Middle East has changed and has a court hierarchy, court decisions, and interpretations and regulations and so forth. I'm going to skip this, but you probably will hear a lot about schools of law, that there are different schools of Muslim law. Islamic law, by its nature, was diverse because there is no monopoly over divine will according to Islamic jurists and the corpus of our legal statutes or commentaries and so forth. Every scholar has the same ability to review the primary sources and to conclude a legal decree or a legal opinion. No one is more authoritative than the other. There's no ecclesiastical hierarchy. There is no church. There's no one pope that says this is what the law is. This created a lot of diversity of opinion. While it may not work for today's world because of certainty that we need for a capitalist system to function, diversity was the name of the game in the 1400 years of Muslim legal scholarship. So you had hundreds of these scholars with followers, and that created many schools of law, meaning kind of like an academic school where everybody follows what their leader has created in way of the hermeneutics of the law, the interpretation, the legal tools to study and interpret the religious text. In the 11th or 12th century, there was probably 100 of these schools. But over time, due to political, social, economic, and intellectual factors, all of the surviving schools dwindle down to 4. So you have Hanafi, Maliki, Shafi'i, and Hanbali schools of law that exist today in Sunni Islam. The Hanafis were the Ottoman Empire. The Maliki school is very prominent in North Africa. The Shafi'i in Asia. The Hanbalis are in the Gulf countries, Saudi Arabia, Kuwait, Dubai, Qatar, and so forth. Marriage in Islam, unlike Christianity and Judaism, Islam looks at marriage as a civil contract. So it is not a sacrament. It's a compassionate, peaceful relationship based on gender equity, not gender equality. The issue of equality is a construct of the 20th century in Western countries. It's a complicated concept when you look at the gender-specific financial obligations to each other, the gender roles, and so forth and so on. So when we talk about gender equality, we have to revamp the underlying structure of society, which we're doing in the U.S. and in many other countries in Europe, and that has been a gradual process to where we are today. Marriage, again, is a civil contract, requires bride and groom to reach majority. That's, again, the current law. There are some arguments and interpretations that once a girl reaches puberty, has her menstrual cycle, she could be 10 or 11. Technically, she could get a marriage, but practically that is something that, never happens, rarely happens. Even there are arguments that even at the time of the Prophet that was not really something that happened with his first wife, because there's all these discussions that, Muslims support child marriage. That's not the case because there is historical context, as we've seen in the Catholic and the Syriac Catholic law allows girls to get married. In the United States, for example, I believe prior to the 1920s, the age of 12 was the age of consent in the U.S. So the issue of age is really an evolving concept. I have a daughter that's 16. I think she may be, after college, still not mature enough to get married. But things change over time. As a marriage contract, there needs to be offer and acceptance and 2 witnesses to publicize the marriage. Non-civil marriages versus religious marriages. Only have religious marriages in the Middle East, but in the U.S. We have, of course, civil marriages. In the U.S., if you had a couple sign an Islamic marriage without registering for a civil marriage license, it's going to depend on the state you are in. That marriage can be considered void, and in some jurisdictions will be considered voidable, and we have a couple of cases that we're going to discuss. As a civil marriage, parties are entitled to include certain provisions. Here are some very popular provisions. finances, marital residence, when you're going to have children, relationship with the in-laws, equal right to initiate divorce, right to work, to education, equal division of domestic responsibilities, restriction on polygamy. So these are types of provisions that a lot of women, Muslim women these days, include in their marriage contract. In other words, on its face, the default patriarchal system gives preference to certain aspects of male dominance in society, but also there are also other aspects where a woman can benefit from the patriarchal system in the sense of her not having this responsibility on the finances. It doesn't work one-way street. Yes, probably more than the majority of the time the patriarchal system is not beneficial to Muslim women or to women in general. But these are a way that Muslim women today are utilizing the civil contract as a way to minimize the patriarchal presumptions. So here you're putting some restrictions on your spouse. I draft marriage contracts for many Muslim women, and the one thing, and anyone on the line that is providing services, you always want to add in your marriage contract the right to dissolve the marriage. Because even though a wife has the right to dissolve her marriage, she has more opportunities than in other religious traditions to dissolve her marriage, but it is not easy with the current religious establishment. So you end up getting stuck with a proceeding to obtain a religious divorce, and husband usually uses that as leverage to extract more financial gain in the divorce process. In every Muslim marriage contract, there's a provision called mahr. It's an effect of the marriage contract. It is not consideration. It is a payment of a sum certain at the happening of a certain event. Unless otherwise specified, it would be at the time of divorce or the death of the husband. Historically, you used to pay this one lump sum up front, but over time, custom has created a division of this amount of money. One portion of it would be prompt, and the other portion would be postponed, meaning the one that you pay up front, that's a separate property of the wife. She gets it right at the time of signing the contract, and then she defers the rest of the balance until the happening of divorce or death. And this amount is considered a debt on the husband. In Iran, they could put you in jail if you don't pay the dower. You get a preferential debt in many other Arab countries. And the mahr is a separate and apart from the wife's right to inheritance and alimony. Yes, a wife cannot be disinherited. She does not receive the equal share, half of the estate or the majority of the estate by Islamic law of inheritance. She receives either a quarter if there are no children, or 1/8 or 1/6, I believe, if there are children. But you cannot disinherit a wife. Any waiver of such can be considered contrary to public policy. Property rights, like Christianity and Judaism, Islamic law does not recognize concept of marital assets or community property. It is title-driven regime. It's a separate regime. Whatever the property is titled in your name, it's yours. You're not obligated to share it. But there are joint property and partnership concepts in marriage, but they need to be in writing. Islamic law of inheritance, which we just explained, you cannot disinherit your wife. Women have legal capacity to contract, manage, and own their property, so that gives them some leverage. How do you dissolve a marriage religiously under Islamic law? There are three primary ways to do that. The talaq, which is the unilateral at-will right of the husband to dissolve the marital relationship without cause. A judicial divorce is based on grounds, and a mutual divorce or wife-initiated. So we're getting close. I only have about 15 minutes to go, so I'm going to skip and get into some of the cases because I have a lot. Let's talk about domestic religious divorces. In these two cases, and the printed material that you have includes a digest or an index of all of the cases that involve, for example, Islamic family law or Middle Eastern family law around the country. So you have the citations for these cases. So in Musa versus Palmer and in Shiko versus Murph, the court made it very clear that a religious divorce in the U.S. is not a substitute for a civil divorce. Because you're going to have a lot of Muslims who go to their religious cleric and they get a divorce and they think they're divorced. You need to have a civil divorce. Now, a religious divorce is valid and does terminate the marital relationship in a Muslim country where it applies. So, for example, going to your local religious person in Lebanon and saying, I want to divorce my wife, and they give you the decree of divorce and you register that decree of divorce, that would be recognized in the United States because it is valid in Lebanon. So that would be considered a foreign divorce. But doing the same thing with a religious cleric in the United States, that will not be valid. Muslim marriages, they're valid whether conducted in the U.S. or whether conducted overseas, with exceptions, meaning there are two jurisdictions regarding religious marriages in the U.S., and we'll discuss them shortly. So withholding religious divorces for extortion, I've explained that, and for those who are providing services or their judges that are on the line, this is something that happens all the time. And courts have created some very ingenious ways to put pressure on the other side within the constraints of our constitutional separation of state and church to secure religious divorce for Muslim, Jewish, and Christian women. In this particular case, Hamid versus Hamid, the husband refused to grant the wife a religious divorce. So then the judge said, you know what, this guy's he's not playing fair here, so I'm going to say that she's never going to be able to remarry because she can't get a divorce from him. And because she can't get a divorce and she can't remarry, then he has a claim for alimony. And he awarded the wife alimony because he said she can't remarry. On appeal, the court reversed, said, look, you didn't have the authority to do that, and you can't pressure him to pay alimony in exchange for an Islamic divorce. I did a workshop for Michigan State judges a couple of years back, and I actually met a few judges who told me that they do this on a regular basis in order to secure an equitable outcome. New York state law has a get law. This is unlike any other state. In New York, you have to plead in your complaint upon entry of final judgment of divorce. The parties will remove all barriers to remarriage. And so if you enter into that case, everybody is bound in their pleading to say they're going to remove barriers to remarriage, which means a religious divorce. This was a statute drafted for the Jewish community because Jewish women were not able to get their gets and they weren't able to get divorces. It has been challenged multiple times on constitutional grounds, but it has withstood constitutional scrutiny, and it's still the law of the land in New York. New Jersey does not have a get law, but there's a recent case, Lowy versus Lowy, even though unpublished. It basically says a court does not have the authority to direct a litigant to give a religious divorce. However, if the parties had agreed, and it's in their consensual agreement, in their stipulation of settlement, or their property settlement agreement, or marital agreement, then I could enforce what the parties said they were going to do. Ohio, on the other hand, says even if it was in the agreement, that is still an entanglement issue, and I don't have the authority to direct a husband to provide the religious divorce. It's a doctrinal determination, and I can't get involved in it. In the following cases, courts refused to recognize foreign divorces obtained unilaterally ex parte by husbands. In most of these cases, they would say that the wife did not receive notice, and there was no due process, and so forth. These grounds on foreign divorces are basic constitutional big picture arguments. Public policy, due process, notice, opportunity to be heard, These, you will see them over and over in the foreign divorce issue. In the following cases, the court did recognize the divorce. In SB versus WA, the parties moved to Abu Dhabi for work. They lived there for many years. There was acts of domestic violence there. The wife went for domestic violence and applied for divorce. And the New York, this was a New York state case, the court recognized the Abu Dhabi decision and said, listen, the divorce decree was obtained after trial and 2 appeals. You participated and you chose that form. So there was no question that the court in Abu Dhabi had jurisdiction. In this particular case, in Akil versus Akil, the husband did not finalize his divorce the first time when he married a U.S. citizen. So then he went back to Jordan, refiled his divorce, and then came back and remarried the American wife. While the court found that the Jordanian divorce was not final because he had the right in 90 days from the date of the divorce to revoke it, it still said it was valid because he did not revoke it and the American marriage subsisted. In the following cases, the validity of the foreign divorce turns on the residence of the parties. For example, in Hussein versus Hussein, the parties lived in Ohio the entire marriage, 25 years plus. Husband goes to Palestine, gets an ex parte divorce, and serves it on the wife. The court said, listen, you didn't even live there. There's no residency in that area. The residency was Ohio, so Ohio will control. Same thing with Aleem versus Aleem. This was a divorce, 20 years that they lived in Maryland. Husband goes to the Pakistani embassy and obtains a religious divorce that is valid under Pakistani law. Court said no can do, will not grant comity to the foreign divorce. Ashfaq versus Ashfaq is a recent 2015 case out of Texas. Parties were married in Pakistan. They moved to the U.S. After a few months they were in Texas, they returned back to Pakistan. While in Pakistan, the husband obtained a divorce. 6 months later, wife comes back to Texas and she files for divorce. What is the wife argues? Hold on. The marriage, matrimonial domicile at the time of the filing of the Pakistani divorce, it was Texas. And the divorce violated my due process because I didn't get an opportunity to participate. So, but took her too much time to get into Texas and to deal with these issues. And so now what happens is the court finds that, you know what, the divorce was proper in Pakistan. I'm going to recognize it because the husband has since remarried. But, you know, I'm going to convert the wife's complaint to a post-divorce petition. And I'm going to divide the marital assets according to Texas community property law. In other words, the court, in this circumstance, the equities considered said, I will terminate status, but that will not determine the financial rights arising out of the marital relationship. And the judge divided accordingly. In Sharif versus Sharif, a very similar circumstance where they lived in New York, but they moved to Egypt, and the husband divorced her in Egypt, and she participated in the procedure in Egypt. And a few years later, she comes back to New York and says she wants support. The court said, comity is going to be granted to this Egyptian divorce. You participated. It's been years. You're not entitled to make an application in New York. So in the marriage license cases, which is really, really important, there's 2 jurisdictions. And I'm going to try to summarize because time is flying. In New York, you are required to get a marriage license, and then you take your marriage license to a civil authority to solemnize your marriage or to a religious authority. If you go to the religious authority before you get a marriage license, or you never get a marriage license, New York says your marriage is still valid. It will be considered avoidable marriage. You could cure the defect, if you demonstrate to the court that you had a ceremony of marriage in your religious community. New Jersey takes the position that the marriage license is an absolute requirement. If you do not get that marriage license and you go to your religious cleric and he does a marriage, your marriage is void under New Jersey law. So these are the two jurisdictions around the country. You have states that say you can get married without a marriage license, and some states say you cannot get married without a marriage license. And these are three cases that dealt with this issue. In Hihi, the court said void marriage. You got married in New Jersey. You only had a Muslim marriage contract. You didn't get a marriage license. Can't help you, wife. In Ilhaf versus Tara, same thing, applying Michigan law. Sorry, you did not get legally married. You did not obtain a marriage license. You only had a religious marriage. Can't help you. In Musa versus Musa, the court said because the marriage took place, the religious marriage took place in Virginia, and Virginia has a similar law like New Jersey that a ceremonial marriage can be cured and be valid, that religious marriage continued to subsist and is valid until dissolved by a judicial authority. In Musa, what happened is that the wife had a religious divorce in Virginia. She married a fella for a couple of weeks. It did not work religiously. She got the divorce. She moved to, I think it was North Carolina, lived in North Carolina and married a fella for 12, 13 years and had children. Court said, sorry, your marriage to North Carolina fella was void because you were not judicially divorced from the religious marriage you had in Virginia. That was a miscarriage of justice, to tell you the truth. I wrote a commentary for the North Carolina Weekly about this case. New York has a fascinating approach for those who want to use creative lawyering. In the matter of Faraj, that involved the validity of a marriage without a license. Husband, resident of New York, he met somebody in New Jersey. He came to New Jersey, brought his religious cleric with him. They got married in a New Jersey household. Muslim marriage, no marriage license. Shortly after their marriage, they moved to New York, and they live in New York. Husband drops dead. Wife goes into probate court. I'm the surviving spouse. Children say, she was his girlfriend, judge, not his legal spouse. So now what happens is the conflicts of law issue is all the time you apply the law where the marriage took place. Well, if you apply New Jersey law, her marriage is void because she didn't get a marriage license. But New York has this other alternative, according to the Restatement Third of Conflicts of Law, that provides, I think it's Article 283, that you can also apply the law of the matrimonial domicile for purposes of validity of the marriage. Court says, hold on, the parties were transient in New Jersey, they lived in New York the whole marital life until he died. I'm applying New York law and validity, and she has a ceremonial marriage. That means it's valid, she's a surviving spouse. Now, briefly on the marriage contract, this is something I will summarize because I have no time. In every Muslim marriage, generally you enter into this Muslim marriage contract, and you have this provision called the dower or the mahr. How do you enforce this in a U.S. court? There's two approaches. The case law, and it's all on my PowerPoint, and you have articles and things attached to the materials. You deal with the marriage contract as a simple contract, or you deal with it as a prenuptial agreement. There's a couple of cases that describe the Muslim marriage contract as a prenuptial agreement and enforced it. But the majority that described the Muslim marriage contract as a prenup and did not enforce it took the position that a prenup has to comply with prenuptial law and jurisprudence. Meaning, for a prenup to be valid, if you're a member of the Premarital Agreement Act, if not, most states incorporate a lot of the similar provisions in their state law, you need to have advice of counsel, and you have to have fair and complete financial disclosures. And there has to be knowing waivers. So when you enter into a prenup, waiving all of your financial rights in the event of divorce, or for a limited amount of money, there's a level of additional protections that our courts have created and interpreted. So a Muslim marriage contract is really not a prenup, because prenuptial agreements were contrary to public policy prior to the 1970s. It's a construct of the 20th century. A lot of people use prenups because they're getting married older. They're having divorces and remarriages, and they have kids from other relationships. They're using it for estate planning purposes. Whatever the reason is, prenups have become an instrument that's utilized in estate planning and marriage planning in the U.S. This was not the case in 7th century Arabia, the birth of the marriage contract for Muslims. So there are different concepts and different instruments. So a Muslim marriage contract is not a prenup. The best way to enforce a marriage contract is through the simple contract theory. There's offer, there's acceptance. As long as there is nothing contrary to public policy, the court will enforce a simple contract theory. You're entitled to this lump sum, but it is not a waiver of all your state default rights: equitable distribution, alimony, counsel fees, child support, and what have you. So I've digested most of these cases that address these general principles and concepts. So some courts have found contract defenses applied, and some courts found that there were no contract defenses and enforced it. I probably will stop, even though I got a lot more slides, and give an opportunity for some questions.
Abed, if you wouldn't mind looking at the presenter chat box, I think you have a slew of questions for you to start off with.
A question about young marriages. I don't have the data or the statistics, but my colleagues at the not-for-profit may. That's one of the reasons why we're really pushing to get this law requiring marriages to be over the age of 18. But it's a good point. I see it in my private practice. There's a lot of young marriages still taking place. Stipulations in the marriage contract that are about the in-laws. For example, we're not going to live with the in-laws. I'm going to get my own house. That I have a right to go visit my family. I'll give you an example of a contract that I had. A teacher from Syria included in her marriage contract that she's the only child and she helps her parents. She gives them 25% of her salary. She put in her marriage contract that the husband cannot object to her continuing to pay 25% of her salary to her parents. So you could put a lot of things in this marriage contract to help undermine some of the patriarchal presumptions in favor of men. As an advocate in GAL, who would be the first point of contact when encountering one of these related situations? One, I'm not sure about what related situations you're mentioning, but it's really going to be very specific. Meaning, if the girl has an older brother, if she has an older sister, I would not talk to the parents because the parents may already be so concerned about their daughter marrying outside of their faith or marrying outside of their race and what have you, that they think they're doing the best thing for their daughter and setting her straight because she's not mature enough, and they're making the decision on her behalf. So I would definitely first talk to the victim, understand the dynamic of the family. Does she have an aunt that is empowered and out? Does she have a brother that she's close to? I would indicate the family structure and the family dynamic with the victim before I decide where to go. Because you may also go to the religious community elders and leaders. You may go to people like me. I'm in a community that I know a lot of people. I may be able to help determine places to go and who to speak to. I don't know what a U visa stands for, so I'm not going to be able. So the person who asked the question about the U visa, if you could explain what a U visa is, I could then help you. No, the jurisdiction, there's a question about does the country of origin of the marriage travel or would U.S. Law apply? Basically, the U.S. system, the subject matter jurisdiction of a family court is based on residency. Doesn't matter where you got married. As long as you're a resident for a year in New Jersey, 6 months in Ohio, 6 weeks in Las Vegas, a year or 2 years in New York City, depending on the jurisdictional grounds of residency around the country, American law would govern. However, the reverse is not the same. Under Middle Eastern countries, subject matter jurisdiction vests in the court based on citizenship and religious affiliation and religious denomination. Meaning, if I am Egyptian citizen and Christian, the Christian court can dissolve my marriage or enter orders related to my family dispute. If I'm Egyptian and I'm Muslim, the civil courts in Egypt would apply, but they would apply Islamic law to my marriage. I do not need to be a resident for a certain amount of time in Egypt for the court to take jurisdiction. So that's the huge difference between American law and Middle Eastern law on subject matter jurisdiction. Residency versus citizenship and religion. Believe it or not, the civil law system, like the French Civil Code, had the ability to dissolve the marriages of French men and women who weren't living in France, who were living in other countries because of their citizenship. But even in the civil law system and in Europe, there's a movement towards domicile and residency like the U.S. system. This issue regarding Jewish divorces, this is a major, major issue for the Jewish community. And like I said, we have the Get Law in New York to try to address that. We don't have specific organizations working on Muslim religious divorces for two reasons. One, it's still an issue that's evolving. I'm hoping to find solutions regarding religious divorces. In fact, there's been discussions with some counsel that we want to see if we can adopt a similar Get Law in New Jersey, because the Get Law in New York also helps Muslim women. And Muslim women do have an avenue to get a divorce more so than under Jewish law. For example, if they can get a judge to understand the grounds and the abuse, a religious scholar may give it to them. But the other way Muslim women are able to get the divorce is by waiving their financial rights, then getting the consent of the husband. So it is not a fair assessment, but it's a way out of the chains of matrimony. You lose money, you pay the husband, you waive your dower, you do something and get the husband's consent. So Muslim women have been able to find some ways out. Yes, it's not perfect. Yes, it's not fair. It's not equitable. So that's why we haven't seen enough on the religious divorces. But I anticipate that there will be coordination with Jewish women organizations and Muslim women organizations to combat this abuse of the religious divorce to extract financial gain and to oppress women in the U.S. So I understand now what a U visa is. So I don't know if it will affect her status A U visa for the attendees means a visa coming into the country based on being a victim of domestic violence or human rights abuse and so forth. It's kind of an exception to the regular way to obtain residency in the U.S. Yes, if the Sharia marriage, let's say, was based on coercion, that she was a child, she was 16, she was 17, she was forced into it, you could use that as documentary evidence. Another question, if a woman becomes a widow and an informant on the death certificate states under Canon Law the deceased were divorced at the time of death, how does the widow disprove the allegations that the couple lived in different states at time of death? Not a legal separation, what steps? Well, first you want to see, if this is in the U.S., we have one thing for sure. A divorce is a judicial divorce. The only legal way to dissolve a marriage, whether a marriage was consummated and created in the U.S. or in a foreign country, is by judicial divorce, a final judgment of divorce. Without a final judgment of divorce, you are the surviving spouse. That's a presumption in many states, even if they live separate and apart. So I would first want to establish the marriage. So if you have a marriage certificate, if you have a marriage license from the U.S., from abroad, that would be your first base of attack. Your Honor, here's our marriage certificate. They're married. She's a surviving spouse. The person who did the death certificate, he lied under oath, or he didn't know the decedent was married. And then you shift the burden on the family of the decedent to prove that he has a legal divorce. I had this exact case. I had this case in Chicago where it's a wrongful death case with a wife. A wife was hit by a car and passed away. Her family, her maternal uncle, filed a lawsuit to seek compensation for the wrongful death. He said that she was single, that she wasn't married. During the trial, something came out that this woman was married, but she may have been separated. They produced a divorce out of the country of Mali. So she was divorced. I was retained to verify whether this is a valid divorce in Mali and whether their original marriage, which was by proxy, was valid. And I was able to prove that her marriage was valid under Mali law and that the divorce was a fraud and it was a forgery. So the husband was the surviving spouse. So
well,
I think we've gone over time, so whatever you say, Carly.
Yeah, but thank you so much. We wanted to make sure that all of or at least most of the questions were covered, and I think you got to most of them. So thank you so much for this presentation. It was informative and intriguing. So we look forward to working with you again. To all the participants, thank you so much for taking some time and participating today. As Alicia and Amber mentioned earlier, we'll make sure that this PowerPoint as well as some additional reading materials are available on our website. And we are going to say goodbye to you now. Please note that once we conclude the webinar, a survey will pop up, and we'd really appreciate your feedback on this webinar for future webinars. Thank you so much. Everybody have a great day.
Thank you.